We hope you enjoy listening to this podcast of St. Louis on the Air, brought to you by University College at Washington University, with undergraduate and graduate programs part-time, evening, and online. University College at Washington University, offering world-class education within reach.
Welcome to St. Louis on the Air. I'm Don Marsh. Our legal roundtable panel has lots to talk about today, from the Kavanaugh hearing and its fallout to a legal maneuver to dodge liability in that Branson duck boat tragedy. And there's plenty in between, too. Joining me in studio are attorneys Bill Freivogel. He teaches journalism at SIU in Carbondale. Mark Smith is Associate Vice Chancellor and Dean for Career Services at Washington University. Also joining us is Marcia McCormick. She teaches law at the St. Louis University School of Law. Thank you all so much for being with us. Good to have you.
Hi.
Well, I'd like to ask each of you, as attorneys, for your takeaway from the Kavanaugh hearing of just a couple of weeks ago. Most unusual in many ways. Mark, I'll start with you.
Well, it was not what you would like to see in a hearing. I think both the inquiry that was made is not becoming to the court, and then I think his attack and suggestion that this was all politically motivated. The Supreme Court is an anti-democratic institution. I think it needs to have a strong reputation. I don't know that helped it, and I think you're seeing folks like Roberts try and rehabilitate the court's reputation, but I don't think it was a good moment for the court.
Bill?
I agree. I thought it was really disconcerting, just from beginning to end. The way in which it was disrupted, the testimony was disrupted in the beginning by protesters in the audience. I might have agreed with the protesters, but they don't get to disrupt the hearing. When Senator Durbin from Illinois said that was their First Amendment right, he was wrong. It isn't. Protesters have been doing this for a long time. I remember this happening when Souter was the nominee, which was a long time ago. But protesters were removed right away, and it didn't totally disrupt the hearing. This was a mess. And then, of course, I was very much reminded of the Clarence Thomas Anita Hill situation. It was exactly the same thing played out. First, the hearings took up the legal philosophy of the nominee, and then there were these sexually related allegations afterwards, where in both cases the women who came forward, I thought were not well treated in the end. Anita Hill, very blatantly so. They went out of their way. The committee seemed at first to go out of their way to respect Dr. Ford, but then you have the president mocking her and saying how we got to worry about the falsely accused men. I really did think that by the end of the second hearing, after Kavanaugh had made this totally partisan, intemperate defense, that he no longer was a person who should be put on the Supreme Court. So I was disappointed by the whole thing.
Marcia, how about you?
Yeah, I'm not sure I have a whole lot to add, actually, to those observations. It's a little, I think especially the comparison to the Hill-Thomas hearings, the way that the hearing was structured not to actually find out. So the allegations about at least knowing about sexual misconduct happened well before any of the judicial temperament part of the hearing, because Kavanaugh had worked with now former Judge Kaczynski in the Ninth Circuit. And so a lot of sort of troubling information was out there on the radar, but was just not necessarily being dealt with by the Judiciary Committee. And so I do think that I don't want to say that a lot of people think that the court is politicized anyway, and this certainly just sort of reinforced that belief.
You mentioned temperament, and I wanted to get to that because it seemed to me that this was transformed in a heartbeat from a hearing basically dealing with the accusation of a sexual assault and became a discussion more so of judicial temperament. The other thing was kind of swept aside at the end.
Yeah. Well, and a lot of that has to do with just sort of the tenor right now about how people are supposed to react and act in public, and how men in particular, I think, are supposed to act to be perceived as strong. And there have been some things said that Kavanaugh was coached to react that way, that he had to come out guns blazing, so to speak. Otherwise, he would be viewed as weak. And it's just this is probably the wrong cliche, but a winner-take-all sort of approach to everything that's completely politicized and over the top all the time.
Bill, I was struck by the fact that former Justice John Paul Stevens came out, as he did, and basically said that on the basis of this temperament issue, he was not qualified to serve on the court, Kavanaugh, that is.
Yeah, Justice Stevens had initially supported Kavanaugh, and I believe he had written a book in which he even had praised one of Kavanaugh's opinions, and he changed his mind after hearing, the Kavanaugh's last angry defense, and thought that there would be so many cases where he really couldn't be, put himself forward as an unbiased justice, that he really shouldn't be on the Supreme Court. As Marcia says, there is a long history of sort of men appearing before Congress, and angry men, and taking on Congress, and ending up triumphant, from Clarence Thomas and high-tech lynching to Oliver North during Iran-Contra. There's a Jimmy Stewart in the fictional accounts, and Kavanaugh did it. But I just thought when he went to the whole extent of saying, with some sort of Clinton conspiracy, himself taking on the Trumpian approach of making stuff up, in a very highly partisan way, that was just way beyond what a person who was expected to be on the Supreme Court should do.
Right, and he was Stevens was saying, this points out potential bias that Kavanaugh would have in cases, and the Supreme Court decides to recuse themselves solely. They make that decision individually. So the other thing that kind of bugged me about the hearing, it wasn't just Kavanaugh, it was the senators. I mean, when we have a society that's so politically divided, you would love to see, and everyone's watching these hearings, you would love to see some good behavior kind of modeled. This is how you disagree on political issues. This is how you have a conversation, instead of everyone getting red-faced and yelling. We've had enough of that.
The bottom line was that it turned out to be totally political anyway. The vote was along political lines.
It was a done deal, right.
Yeah, right. And the Chief Justice came out later, and I interpreted it as something of an effort at damage control, because he came out and basically reaffirmed the political independence of the court. Did you see it that way, Marcia?
I think, because, at least the news articles are treating it as damage control as well, because they're careful to note that Justice Ginsburg and Justice Sotomayor have also publicly said important things about the court needing to be independent, so that altogether this looks like a very united front by justices on different sides of the political spectrum to reaffirm their independence.
Right. Final thoughts on this?
Well, I mean, I think Chief Justice Roberts is especially concerned about the legitimacy of the court going forward, and the legitimacy of the court is called into question by these kinds of events. So you can see that he would want to do everything he can so that the court is seen as independent and not partisan. And I think I hate to make predictions, but I think that may play into the way he will end up actually voting and participating in some of the really tough questions that may come forward about whether or not to overturn Roe versus Wade or go back on same-sex marriage or any of these sort of 5-4 issues before the court, that even though he might feel one way, he won't want the Supreme Court to be throwing out precedent after precedent after precedent that's on what seems like just a political vote.
It's going to take a long time for people to forget that hearing as the court session moves on and decisions are rendered over the course of the next months. No question about that. One other thing before we take a break that I wanted to get to, and we won't spend a lot of time on this, it's the Stormy Daniels situation. She gets so much publicity, but Donald Trump, Marcia, won one here with the case against her, the defamation of character suit.
Right, and this is super interesting if you're a lawyer. Maybe slightly less interesting in the details if you are not a lawyer.
If it involves Stormy, most people are interested.
Yeah, so she sued him over a tweet, right? And Texas law applied, but the president's defense was something called an anti-SLAPP statute that basically says that when defamation suits are used to defeat public commentary on an issue, they can be dismissed and you can get attorney's fees. And he won using that anti-SLAPP statute, which is really unusual because usually it's used by the people who don't have any power against the people in power. So, and it doesn't affect anything about the non-disclosure agreement. So it's certainly interesting and a win, but I'm not sure it gets him where he wants to be.
Yeah, she has to pay his legal fees, and
right.
That's it. And it's going to be appealed. Michael Avenatti, Bill, who's not shy about coming forward on anything, it seems, is going to appeal.
Yeah, I mean, there are there's a number of ironic things about this, in that Trump has been saying it's too hard for a person like Trump to win a defamation case because and Congress should pass some laws making it easier. Well, he won because of New York Times versus Sullivan and the requirement that there be actual malice proven. So the very part of the libel law he wants to get rid of and probably can't is why he won. I have a friend, Mark Sabelman at Thompson Coburn, who wrote an interesting little blog post about this case, and he was pointing out that before you had the sort of wild, opinionated claims that you have on the internet every day in billions of bytes, and before you had this sort of wild allegations being made, he didn't use the term wild, I'm using wild, by a president of the United States like Trump, that probably this would have seemed like the kind of defamation case that a person like Stormy Daniels could win. Mm-hmm. The Supreme Court said that when somebody expresses an opinion that is based upon facts, that whether facts are true or not are relevant, and so you can sue a person for an opinion. So she could sue Donald Trump for saying it was a big con job to say that she was threatened by a person in a Las Vegas parking lot if she were to disclose her relationship with Trump. So before the internet, for Trump to say that wasn't true, that could be proven or disproven more or less, and could be the basis of a defamation suit. But things have gotten so crazy that now this is considered to be rhetorical hyperbole. And virtually everything, is suddenly becoming rhetorical hyperbole. So how does a democracy figure out, if everything's rhetorical hyperbole and can say anything you want, how do you get to actually truth versus not truth? Yeah.
Well, we have to take a break. Mark, do you have anything to add?
I think the most important thing we'll continue to hear from Stormy and Michael
Avenatti.
Yeah, this is not the end of her lawsuit.
Okay, let's take that break now. We'll do that, come back and continue our conversation with our legal roundtable panelists. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. We have got a free event coming up here at St. Louis Public Radio this Wednesday. Join us at 6:30 that evening for our Missouri Ballot Issues Forum. I'll be talking with proponents and opponents of 4 major issues before Missouri voters this fall: Proposition D, Amendment 1, Prop B, plus the 3 competing measures that would legalize medical marijuana in the state. For details and to register for the free event beginning promptly at 6:30 p.m. on Wednesday, go to stlpublicradio.org/ballot. Now back to our legal roundtable panelists, Marcia McCormick of St. Louis University School of Law, Mark Smith, Washington University, and Bill Freivogel of Southern Illinois University in Carbondale. Okay, we've been reading today and over the weekend that the Trump administration is considering and is very likely to change the legal definition of transgender to have it determined solely, or gender determined solely by genitalia at birth. Marcia, this is in your wheelhouse, isn't it? What's to be gained by doing this for the administration?
Well, there are a number of things that are to be gained. First, what's interesting is that the regulations that are supposed to be changed actually affect very, very, very few cases, very little, when it comes to the federal government's enforcement of the prohibition of sex discrimination. The regulations are supposed to be issued by the Office of Civil Rights of the Department of Health and Human Services, which really only governs educational programs, or at least the Title IX protection, which is the anti-sex discrimination protection, only covers educational institutions that receive funding from HHS. Title IX is mostly actually enforced by the Department of Education, which is not yet issuing these kinds of regulations. And the employment laws that prohibit sex discrimination are enforced by the EEOC, which is yet a third agency. And actually the Department of Labor as well, which is a fourth agency. So this particular change is not going to affect very much, except that it does telescope what the administration is likely to do with the Department of Education's regulations, at least. It is unlikely that, and this is a position or a similar position that the Department of Justice has taken in litigation as well. The challenge for the administration is that the courts have pretty uniformly said that gender identity, being transgender, is sex for purposes of all of these statutes that prohibit sex discrimination. So the administration can say this in their regulations, and maybe courts will give some deference to it. But since the vast majority of decisions in this area have said that that gender identity is sex, it's unlikely to have a real effect in terms of in terms of policies once they get challenged, at least in litigation.
So it's more to make a political point, perhaps, than anything else?
Perhaps, or to try to set the stage for litigation that will reverse those earlier cases. But it's going to be hard to do that because it's going to require courts sitting en banc, for example, and a whole big, complicated process.
Any thought, Bill?
Well, but I guess U.S. Supreme Court hasn't ruled on this issue. So if they are able to set up those legal challenges you're talking about, they could get a favorable decision before the U.S. Supreme Court.
Yeah, if they can get there.
Yeah.
Okay, well, we'll move along unless we have anything else to add. I'd like to move to that the duck boat story that I mentioned early on, that horrible incident in Branson. I guess it was in July. 17 people were killed, and the families of those victims are suing. But now the companies involved with the duck boat company are citing an 1851 law to try to work around this. Mark, what is that all about? What's the law, and how could it help the companies?
Yeah. So the law limits damages that you have on when a maritime vessel is totaled like this. These types of situations are not unusual. They're completely unusual. Sometimes you'll have a statute that provides a sole exclusive remedy, so that blocks other things. I think it's important to note that this is happening while negotiations are going on
for settlement.
For settlement, right? So this may just be a move as part of keeping their options open and trying to put some more pressure on the plaintiffs to settle.
Bill, my impression is that that part of this law that they're citing was the fact that the boat carried no freight, carried people, of course, but no freight, and that the boat was a total loss, therefore they're off the hook.
Yeah, it would be, I think that's right, and it would be, a terrible miscarriage of justice if a law from the middle of the 19th century were to get in the way of these people being able to collect for what seems to have been very clear negligence on the part of the operator of the boat.
Hey, Marcia, any thoughts from you? Shall we move on?
Not really. I think it's covered well.
Okay. Now let's turn to Missouri voter ID. And Bill, I'll turn to you for this. The status of the Missouri voter ID law is a little bit in limbo right now. It's being kicked around. It has to do with the alternative if no voter ID is produced at the ballot place. Those who don't have the ID would be required to sign an affidavit that they're qualified to vote. Well, the judge says voters don't have to show that affidavit, apparently. What does all this mean for Election Day in 10 days or whatever it is?
Well, as you say, it is confusing. I mean, I think the judge's ruling, Judge Callahan, was, I thought it was an excellent ruling. He upheld most of the law, which I think is sort of too bad, but it's probably legally correct. I mean, I think these voter ID laws are just a way to try to hold down voting by people Republicans don't want voting.
At least it's not Georgia.
At least it's not Georgia. Yeah, but Judge, I thought that Judge Callahan looked at this very carefully, and he pointed out that the affidavit that a person has to sign if they've, say, gotten to vote based on a utility bill or some other non-photo ID identification, that the affidavit they have to sign actually requires them to, under penalty of perjury of being prosecuted, to assert something that's false. That they have not presented an ID that enables them to vote. Well, the utility bill is an ID that enables them to vote. So it was like a self-contradictory affidavit that required them to swear under penalty of being prosecuted to something that was false. And so the judge said that they could not require signing that statement. And of course, it's the signing of that statement that can cause people, when they see they could be prosecuted for something, to be afraid to use, say, the utility bill as the basis for them to be able to vote. So I guess the Ashcroft, the Secretary of State, and Hawley, the Attorney General, are trying to get a stay, so that, because they say they've already trained the election workers to require that affidavit.
But so far, they haven't filed anything, I don't think. I couldn't find it. And
they said they were going to.
They were going to, and the ruling came out on the 6th.
Yeah,
We've got the election coming up. So you kind of wonder, and I know there was the Democrats some of the elected officials said, hey, don't appeal this. That was like a few days ago. So you kind of wonder, are they going to do this or are they not? And what's taking so long? Yeah,
I actually think that the even more interesting part of the judge's order relates to the advertising on the voter ID, the new voter ID requirement. So the judge also said that the advertising connected with it misled the public and misled polling place workers, that people did need a photo ID, a driver's license or something like that, when in fact they don't. And that now there's an injunction so that any advertisement of this has to include all the forms of ID that people can use.
Right, and so that was the advertising that Ashcroft had been promoting, and had been responsible for.
So I think there's an effort to have lawyers at the polling booths. 'Cause I've done this in the past. I think I'm going to do it again this time, where you are looking for these kinds of problems to make sure people understand their rights and are not kept from voting because they don't understand the rules.
But the really sad thing about this, I think, looking at it sort of globally, is that all of these laws, which have been passed through the Midwest and the South to require voter photo ID on the basis of voting fraud, are really just a modern-day version of trying to keep down the vote that Republican candidates don't want to come out and vote against them, because it's the 5% of people who have trouble getting these, who don't have the photo IDs, are people who are most likely to vote for Democrats. And the Supreme Court has managed to throw out the key parts of the Voting Rights Act And it's just so sad that here we are in the 21st century, and these are just new methods of trying to hold down the vote.
Well, I mentioned Georgia a couple of moments ago, and I think some 70,000 people can be purged from the rolls there for very simple oversights and some of their paperwork. And all of this is being engineered by the candidate for governor, who's the Secretary of State, who oversees the whole election process.
Yes, and it stands to benefit. In a very close race, those votes might well be the deciding ones.
Well, that's a lot of people.
And even if you don't agree with these political reasons, that this is what's really happening on. It's Republicans trying to keep down Democratic voters. It's still the law is it's a solution in search of a problem. Mm-hmm. We don't have a problem. I mean, we have not documented a problem with people voting, who are not supposed to vote. And so why do you come in with all these solutions to a problem that doesn't exist?
Right. Yeah, there literally have been no cases of voter fraud, I think, in the entire country. And if there have been any, one or two,
just
it's
a
very,
handful.
very minor. Yeah, okay. Well, let's move along. This is sort of complicated. This is the St. Louis juvenile parole suit, is the way I have it written here. Looks like juveniles sentenced to life without parole in Missouri for crimes committed when they were younger than 18 years old may have another chance at parole. A federal judge calls the parole board practice unconstitutional, that practice being that they would not be eligible for parole for those who are under the age of 18. State has 60 days to come up with a plan. What do you make of all of this, Marcia?
Well, it's interesting that the state has not been able to really comply with the Supreme Court's decision that life without the possibility of parole for juveniles was unconstitutional. And it's also interesting in light of the things that have been happening in Washington State, for example, where their state Supreme Court found that the same kind of practice violated their state constitution. And it doesn't seem like it would be that hard to come up with an opportunity that's a real opportunity for people to satisfy parole requirements. And it seems like the judge really laid out what those requirements might even look like that could be communicated to inmates. So I think it would be, given all of those things in the roadmap, that the state has an easy way forward.
And here the situation, you had four people seeking parole, and they said, look, you just gave them a boilerplate, like kind of 2-page denial. You're not taking this seriously. They have a constitutional right, and you're ignoring it. Mm-hmm. So this was brought by the MacArthur group here, the public interest group.
Mm-hmm.
Right. Okay. Anything else?
I mean, there's sort of a Missouri history to this. I mean, it was a Missouri Supreme Court that first said you cannot execute juveniles, and then that led to then the Supreme Court agreed with Justice Kennedy and writing that opinion, and then they took the next step, saying also not life without parole for juveniles. So all based on the idea that juveniles' brains have not don't have the level of maturity to have the same kind of culpability, and they should be able to show they've rehabilitated, and that's what this order, Nanette Lowry's order says, is that the state has to come up with this plan to give them a meaningful opportunity to obtain release based on maturity and rehabilitation.
Mm-hmm. Who comes up with the plan? The state has to come up with a plan. Who actually would be involved in something like that?
Parole board?
Yeah, I assume
consulting with the Attorney General, I would guess.
Probably.
It's not something that would have to go to the legislature necessarily for some sort of
I don't think
change.
So.
No.
Okay. All righty. Al Watkins is a name that sometimes brings a smile to faces people who are in the legal profession. I know a few people in this room perhaps are guilty of that. He is, of course, the attorney who represented the ex-husband of the woman who was involved in the Greitens invasion of privacy case that we all heard so much about for so long. He has admitted that he violated a court order which had prohibited attorneys in that case from making public statements. He made many public statements, and now he's going to pay the price. What is that price, Bill?
Well, 100 hours of talking to lawyers and others around the state about the importance of complying with a judge's orders.
And he's got to pay Jerry Carmody's fees,
And Jerry Carmody's fees.
which I'm sure are substantial.
And Jerry Carmody is
He's a lawyer at Carmody McDonald, but he was
Representing
appointed.
The special prosecutor.
Yeah,
Was he special
I think so.
prosecutor?
And he's a former St. Louis City Circuit assistant circuit attorney.
You know, I'm really glad that a judge cracked down on Al Watkins, but it's a little bit scary to me, the thought of Al Watkins spending 100 hours lecturing on ethics to Missouri's lawyers. I'm afraid of what kind of ethics they would take away. I mean, this is the guy who went on television at the height of the Ferguson protests, and he claimed that many African-American women's babies had been sold out of Homer Phillips' parking lot. And this is the guy who's going to go tell Missouri lawyers about how to be ethical. I guess he also gets, maybe he even gets to have credit on his his yearly. He has to have a yearly. His
CLE,
continuing education
legal
for
education.
all the hours in which he prepares. And I know he gets to count towards the 100 hours, the preparation time as well as the travel time to the venue. I'm not too sympathetic towards.
Right. You have a thought on that, Marcia, or you want to defer?
No, I'll defer on that one.
Okay. Well, one thing he gets is a lot of publicity, and I know there are lawyers out there who don't mind publicity of any kind.
And he may be one of them.
Yeah, it may be. Let's take another break. We'll do that now and come back to continue our legal roundtable panel discussion when we return. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU. And welcome back as we continue with our legal roundtable panel of Bill Freivogel, Mark Smith, and Marcia McCormick, all attorneys, discussing issues of the day in the world of the law and the legal world. Okay, here's an unusual one. At least it seems so to me. And that is the ruling by the United States Supreme Court on the issue of hair braiding here in the state of Missouri. Unusual for the Supreme Court. It vacated a lower court ruling requiring Missouri hair braiders to undergo extensive and expensive training to obtain a cosmetology license. Ironically, that training does not include hair braiding. So where the heck are we, Marcia? This is a weird one for the Supreme Court, I would think.
It is and it isn't. So really, the Eighth Circuit's decision was vacated because the state said that they had come out with new rules. Right. And so really the appeal or the decision was moot because the rules that got upheld no longer apply. But states do this kind of regulation of professions all the time. And hair braiding is one in particular that states are often regulating under purportedly for public health reasons, creating a lot of limitations on people when there's not a great demonstrable public health need. It makes a lot of sense when you're talking about, dentists, doctors, lawyers, but when people are practicing professions that don't really create a great risk to the public health or to consumers, it doesn't make as much sense to limit entry into those professions. And of course, this too really impacted the African American community in a way that did not impact the white community.
That's kind of what caught my eye. I mean, it has the scent of discrimination somehow. Somebody wants to get at this particular group. Do you sense that, Bill?
Yeah, I think that's right. I mean, I think that's the sort of maybe the basis of the original law that then the Missouri legislature changed. I mean, one thing about this is that this is the kind of situation where we in the media oftentimes don't. We mislead people about the Supreme Court. I mean, the Supreme Court ruled nothing on this. They didn't say anything about whether you can make lots of rules for hair braiding or you cannot make rules for hair braiding, or this is discrimination or not discrimination. All they said was, Missouri changed the rules. This case is moot.
Yeah.
Go away. No decision. Maybe there'll be future challenges to the new Missouri law's requirements on hair braiding, but the Supreme Court said nothing on hair braiding.
Well, how does something like this get all the way to the Supreme Court?
Well, it gets there because there is a sort of libertarian organization called the Institute for Justice, I think, that supported a local hair braiders challenge to Missouri's very sort of requirements for lots of training for this sort of thing, and so then the case, and there's that is a fine challenge. It goes to courts. A Circuit Court of Appeals has an opinion on it, and meanwhile, the Missouri legislature says, "Oh, we're going to change the rules." And so then the whole thing has to start over again, basically.
And this group has been bringing these lawsuits, I think, around the country, focusing on it. This is an interesting area of the law, because when you step back at it and look at it, everyone just thinks of the law as something you need to comply with, that I have to do this, I got to be careful about this. But business people have figured out you can use the law to hurt your competition. And so when taxi cabs are a great example. I can't just start a taxi business. I have to go through all this licensing. Well, part of that is to protect the public, but an extra benefit is it restricts the number of taxi cabs and allows prices to stay high. And then when we have a new entrant, like Uber or Lyft, we restrict them. And maybe we restrict only certain taxi cab companies to pick up at the airport and not others. And there's all these ways that businesses have figured out to use the law on something called Porter's Forces. It's a business school concept. But you can use this to kind of hurt the competition, to protect yourself, to get more suppliers in, to get more customers in. And like I said, it's something I think most business people, or many business people, have figured out. But most people just think of, the law's out there. Nobody thinks of it that way, but they do.
Do we have any sense of what the new law is going to, how that reads with
I think there was some
training for hair braiding?
They were talking about a 4-hour video, and
much less.
Yeah, much less. Yeah. Before it was like 4 years. Or it was like
1,500 hours.
1,500 hours.
Yeah.
I mean, that's a lot.
And very expensive. And as a matter of fact, as I mentioned earlier, it doesn't even include the issue of hair braiding in the existing law, the former law, whatever.
1,500 hours. I mean, think about the average law student goes to class 15 hours a week over 3 years. How many?
I can't do that math.
I can't either. Yeah, that's why we're not in business, right?
Yeah. Okay, well, let's move on to another one. And this is another complicated issue, and that's why I'm so glad you're here to straighten it out for all of us. The Disciplinary Council, which investigates lawyers' misconduct, is keeping alive the case against 2 former St. Louis prosecutors charged with covering up an incident in which a police officer allegedly beat up a handcuffed suspect. The council rejected proposed reprimands against Ambry Schuessler and Katie Deerdorf and is recommending suspension of their law licenses. Neither of these young ladies is currently with the Circuit Attorney's Office. Okay, Marcia, what now?
Well, so this is after a hearing, right? So the disciplinary entity wasn't satisfied with that public reprimand, which found that actually justice had not been injured by their actions. And so what's next is the disciplinary entity gets to try and make its case for the suspension. And
they would do that to the Missouri Supreme Court.
Supreme Court.
So I used to chair one of these disciplinary panels, and so we would get together like once every month or two, and you'd hear all these complaints, and most of the time the complaints were nothing. And then, but something like this would obviously be very serious. We would make a recommendation, and then it would go to this next level. But the office of the chief disciplinary officer always had ultimate authority over it, and most of the time would just defer. But obviously this case they feel is an important case, and so they're taking it to the Supreme Court for more serious. And one of the lawyers involved, faced criminal charges. I think received something like a year and a half of probation.
That was Beth Worrell, I think.
Right, exactly. And the police officer involved went to jail. So from a very prominent police family.
Right. I mean, this is a fairly amazing incident. You know, we have 4 young women lawyers in the
3 lawyers, one intern.
One intern
Right.
in the circuit attorney's office, who seem to have covered up this Detective Thomas Carroll beating a handcuffed suspect who he suspected of having stolen his daughter's car, and Carroll went to prison. I think for 4 years.
Yeah.
And the thought that these women would just be who Carroll told about it and who knew about it and talked to each other about how they would cover it up. The thought that they would just be reprimanded.
And who are officers of the court, who
Officers
have
of the court,
affirmative duties.
I think incredible. I mean, I think this is a good action by the Office of Disciplinary Counsel to say that there should be more consequences for that. This is a sort of colorful case in that 2 of the women, I guess, are daughters of former professional athletes.
Laurel and Deerdorf are familiar names to the sports community here. Marcia, what does a suspension of the license actually mean? Obviously, you can't practice law when your license has been suspended. But in practical terms, what does it mean?
Well, it means that in practical terms, it means depending on your employer, you may lose your job because since you can't represent clients, you may be very limited in what kind of work you can do. Future employers are definitely going to be a little bit wary if you don't keep your job, for example. It can mean the end of a legal career for a lot of people.
Well, one of the 2, I think it's Deerdorf, is now a public defender in Denver, I
saw
believe.
that. Yeah.
So if the license were suspended here by the Missouri Supreme Court, could she continue to practice in Denver?
It would depend on what the Colorado rules are and whether the Colorado Supreme Court or disciplinary authority would she would need to report it actually to them, and they could take action to suspend her license because it's suspended here. And often states will do things like that.
Reciprocity agreements, that sort of thing.
Sort of, yeah. It's basically the fact that you've been found to have done this terrible thing someplace else means that you also are violating the rules regarding your license here in this state as well.
But does not necessarily mean it. But,
Right.
But I agree with what you're saying. But yeah, that could open up. And obviously you need a law license to be a public defender.
Yeah.
Okay. And
it's interesting also for lawyers who are in private practice, if I'm suspended for a year, well, somebody else has got to take over my clients for that time. And these guys always get in trouble because they want to, I'm suspended. Maybe I'm suspended because I haven't paid my taxes or something, and then they start practicing law, and then you get in real trouble for practicing law when you're suspended. That's not a good thing.
The other Schussler, I think the name is practicing with a firm in Clayton, I think. So she is still here. Okay, well, we'll go back to the Kavanaugh case here because we have a listener who has a question, and his name is Robert. He says, and he put this on our St. Louis On the Air group page, by the way, which is available on Facebook. He writes, to what extent do your guests think bitter confirmation hearings like Kavanaugh's affect the legitimacy of the court? And what steps can the court take to preserve its legitimacy, particularly since Senate rules changes make it easier for more polarized nominees to be confirmed? Anyone have any thoughts on that?
Well, I think bitter confirmation fights like this definitely affect the legitimacy of the court because it makes it look as though the court is political. A lot of people, including law professors, will say, well, that's just the truth anyway. These justices usually vote their political predilections anyway. But, the sort of, the reality or the myth of the Supreme Court being above politics and trying to find constitutional principles that apply regardless of the political leanings of the people on each side of the case. That's really an important principle. And so I think it does, for the confirmation hearing to be incredibly political, then makes the Supreme Court itself look political. And when then a lot of the 5-4 decisions are Republican appointees voting on one side and Democratic appointees voting on another, that just sort of reaffirms that that view. And it's become more that way because it's a lot easier these days to, or the presidents are very, very careful to appoint justices who are very predictable, who have been federal judges long enough that they know exactly how they're going to vote. The Federalist Society on the Republican side has been really good at, really effective at pointing out what judges and justices can be counted on to be ideologically conservative and originalists, and so that's why we end up having, I think, a Supreme Court that is very much more divided like that.
Marcia, to that I would say, so what if the legitimacy is tainted? It's the Supreme Court. Where do you take it? I mean,
who do you appeal to?
Yeah, right. Where do you go?
I actually joke a little bit. I teach federal courts, which is all about the Supreme Court and the judicial branch, and I joke that it's sort of like asking whether God can make a rock so big he can't lift it half the time in all of the cases that we read, because really there aren't limits on the court. But legitimacy is still important because the court really only has its sort of political capital in order to get people to comply with its rulings. The federal judiciary is pretty well acculturated to comply, I think. I'm not sure the political branches necessarily are. And so there's little, I think, that the court can do to maintain its legitimacy other than try to be as incremental as possible, not have a lot of 5-4 decisions, not overrule a lot of cases for a while, as a way to sort of say this is, we're not engaged in the business of politics.
And I think this legitimacy is important because it's with the other branches, the executive and the legislative. The executive branch has got the Army. They've got a lot of power. Legislative branch got the money, a lot of power. The court, all they got is some cool-looking robes. That's it. They can't make things happen.
The power to write a strongly worded letter.
Yeah, right. Exactly. Which everyone's scared to death.
Hypothetically, though, if the Supreme Court ruled to overturn Roe v. Wade, it would still be overturned.
Yeah.
Yes.
Yeah.
But it might hurt the legitimacy of the court to do so when it is a precedent that has existed for as long as it has, that it's been found to be workable, that it was reaffirmed by, a court 25 years after it was decided. So for now, suddenly for the Supreme Court to say, but it's not right any longer, I think it would hurt the legitimacy of the court.
And think of some of the... go ahead.
I was going to say federalism is the problem there, that there are a lot of states teed up to enact even more restrictive laws, and if the states start not paying attention to what the Supreme Court says they have to do, we are in real trouble, I think.
Right. Think about like during the civil rights where you have the Supreme Court saying you have to desegregate, and the states saying, make me. It was Eisenhower going in with the National Guard that made them. Not the court didn't walk down there and do it.
I mean, old people like us remember the days when you would drive around on a car trip and you'd see impeach Earl Warren signs, billboards all through the South, because they were part of massive resistance to Brown versus the Board of Education. Yeah. I thought it was sort of notable. We were talking earlier about Chief Justice Roberts talking about the legitimacy of the court and the importance of independence, and citing Brown versus the Board of Education as being a perfect example of how important it was for the Supreme Court to be independent of what the politics of the day would support.
And the thing is, too, because I worry when people hear this, that they start thinking, well, the Supreme Court's in on it, and these guys are Democrats and Republicans, big D, and I think it has more to do with maybe just some views of what the government should be like. We should have a small federal government or a large federal government, and the idea that, the Constitution's a pretty brief document. It doesn't answer every question. And, I've said this before in your show, but it's like my wedding vows, my marriage vows. They're pretty vague. They don't say how many times I get to play poker every week, we have to work that out.
You keep pointing that out to your wife, do you?
You're on dangerous turf with that, Mark.
She's a strict constructionist. If it doesn't say anything about it, it's not in there.
We've got to end the conversation here. I want to thank you all. Marcia McCormick, thank you for being with us once again. It's been too long since the last time. Bill Freivogel, thank you. Mark Smith, thank you.
Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.